For God's sake, America already has more guns than people. How many guns do we need until everybody is safe?
Here's a 12-round magazine. This magazine would be banned under this current bill. It doesn't fit.
That men and women in this country have the right to defend their own lives.
To propose regulations to ban all devices that turn legal weapons into machine guns.
Americans have the fundamental right to keep and bear arms that shall not be infringed.
Recent Ninth Circuit Court decision. Let's talk about this recent explosive news that's got a lot of folks in the gun rights community scratching their heads and shaking their fists. The Ninth Circuit Court's latest decision on California's mag ban. It's the kind of news that makes you wonder just how the legal system works, or sometimes doesn't, and how it can have a massive impact on our everyday lives.
A critical and urgent issue: gun violence in America. We're here because gun violence is destroying community.
Our Second Amendment. It's a hell no to government trampling on our freedoms.
You see, California is no stranger to the gun control debate, and the state has a history of imposing some pretty strict firearm regulations. One of those regulations is the ban on high-capacity mags, where high capacity is defined as having more than 10 rounds. The recent Ninth Circuit decision, though, well, it's got people talking. And when I say people, I mean gun owners, Second Amendment advocates, and anyone who cares about their constitutional rights. This decision has sparked significant debate, and for good reason. The thing that's got a lot of folks up in arms is that the Ninth Circuit decided to stay a judge's second order in a case known as Duncan versus Becerra. In this case, Judge Benitez had placed an injunction against California's enforcement of what they call high-capacity mags. It's important to note that the number 10 was plucked seemingly out of thin air. Nobody really knows who decided that more than 10 rounds is the tipping point from good to bad. Now, why is this decision such a big deal? Well, for one, it shows just how far the Ninth Circuit is willing to go to support California's gun control measures, even if it means trampling on the Second Amendment. They're essentially saying, hey California, go ahead and infringe on those rights, we've got your back. But here's the kicker. They're not entirely sure they've got their legal ducks in a row. They're asking the parties involved in the case whether the en banc panel, a group of judges, should even have heard the case in the first place. In other words, they're questioning their own decision. This has raised eyebrows, to say the least. It's like a football team calling a timeout, then huddling up to ask, hey, did we make the right call there? The fact that the Ninth Circuit is second-guessing its own moves is, well, baffling and somewhat alarming, especially when we're dealing with something as fundamental as our constitutional rights. So what's the bottom line? This recent Ninth Circuit decision on California's mag ban is raising all sorts of questions and concerns. It's not just about the ban itself, but the way it's being handled by the very court that's supposed to uphold the law.
Running for President of the United States wanted to strip away our enumerated constitutional rights.
Americans have the fundamental right to keep and bear arms that shall not be infringed.
It's a reminder that the legal system can be a tricky beast, and sometimes it feels like a game of chess where the pieces move in ways that leave you scratching your head. One thing's for sure, this isn't the last we'll hear about the California mag ban, and the debate surrounding it is far from over. In the meantime, it's a stark reminder that even decisions made in the halls of justice can be met with skepticism and scrutiny, especially when our cherished rights are on the line. So stay tuned, because this one's far from checkmate. Judge's injunction. Let's dive into the nitty-gritty of what's been going down in California with the high-capacity mag ban. Now, you may have heard about this injunction thing, and it's a big deal. So what's all the fuss about? First off, a judge, Judge Benitez, took a bold step by issuing an injunction against California's ban on high-capacity mags. What this means is that he said, hold on California, you can't enforce this ban just yet. The reason behind this injunction is that Judge Benitez raised some serious doubts about the constitutionality of the ban. You see, the ban defines high capacity as any mag that holds more than 10 rounds. That's the magic number, 10 rounds. It's kind of like California rolled some dice and decided that anything beyond 10 rounds is a no-go. But Judge Benitez wasn't so sure about that number or the ban itself. In his view, and in the view of many gun rights advocates, the ban seemed to infringe upon the Second Amendment rights of Californians. The Second Amendment, for those not too familiar, is all about the right to bear arms. Judge Benitez felt that the ban went too far in restricting the rights of law-abiding citizens. He didn't just mumble these concerns to himself either. He made it official in his legal ruling. In his eyes, the ban wasn't just a minor inconvenience, it was a potential violation of a fundamental right. Now, you might be thinking, what's the big deal about mags with more than 10 rounds?
Most significant federal gun restrictions in decades on Friday following years of false starts and failures to tighten gun laws.
But, Madam Speaker, guns have been prevalent in the United States of America since before our founding.
Well, for a lot of gun owners, it's a matter of practicality and self-defense. Some firearms are designed to use mags with larger capacities, and they argue that such mags can be crucial in life-threatening situations. So Judge Benitez's injunction was like a timeout in the basketball game. It stopped the clock, paused the game, and made everyone take a closer look at what was happening. It wasn't a permanent victory for gun rights advocates, but it was a significant move. And that's why this injunction against California's high-capacity mag ban is such a hot topic. It's not just about the ban itself, it's about whether or not the ban tramples on the rights of law-abiding citizens. It's about questioning the constitutionality of laws that restrict something as fundamental as the right to bear arms. So there you have it. A judge put the brakes on the ban, and he did it because he thought it might infringe upon our constitutional rights. Arbitrary 10-round limit on mag capacity. Let's talk about this magic number that's causing a stir in the world of gun regulations, the 10-round limit on mag capacity in California. It's a number that's been met with a lot of skepticism, and here's why. In the Golden State, any mag that holds more than 10 rounds is deemed a high-capacity mag. That means if you've got a mag that can handle 11 rounds or more, you're on the wrong side of the law. It might sound simple, but critics argue that this number doesn't make a whole lot of sense, and that it could be infringing on our precious Second Amendment rights. The question that naturally arises is, why 10 rounds? Where did that number come from? It's as if someone in California's legislative corridors decided to play a game of darts with a blindfold on and said, "Yep, that's our limit." Critics contend that this arbitrary number lacks a clear rationale or justification. There's no apparent scientific or practical reason behind it. In fact, it appears to be more of a round number, pun intended, than anything else. So why is this important? Well, the Second Amendment of the United States Constitution, often referred to as the right to bear arms, is a cornerstone of American liberties. It's the rights that's been enshrined for centuries, allowing citizens to protect themselves and their families. But when the government starts putting restrictions on something as basic as mag capacity, it raises eyebrows. Gun owners and Second Amendment advocates argue that this limit might infringe upon their right to self-defense.
Supporting the National Organization Women's Legal Defense Fund. Now, I didn't know.
To propose regulations to ban all devices that turn illegal weapons into machine guns.
You see, different firearms are designed to use mags with different capacities, and sometimes having more rounds in a mag can be a matter of life and demise in a dangerous situation. Critics believe that the arbitrary 10-round limit isn't just an inconvenience, it's potentially denying people the ability to adequately protect themselves and their loved ones. The debate about this limit is part of a larger conversation about the balance between gun control measures and preserving our constitutional rights. It's a debate that's been ongoing for years, and it shows no sign of slowing down. So the 10-round limit on mag capacity in California isn't just a random number, it's a number that's at the heart of a contentious and passionate argument about our rights and how far the government can go in regulating them. The question remains, is it a reasonable restriction or an arbitrary line in the sand? And that's a debate that continues to rage on in the world of gun regulations. Ninth Circuit's unusual request for briefs. Hold on to your hats, folks, because the Ninth Circuit Court just pulled a move that's raised more than a few eyebrows. They've asked for briefs from the plaintiffs and defendants involved in the case, and it's a move that's got people wondering if the Ninth Circuit is playing a game of, are we doing this right, in the middle of a legal battle. You see, it's not exactly common for an appellate court like the Ninth Circuit to go, hey, can you guys tell us if we're doing our job correctly? But that's essentially what they've done. They've asked the parties involved to submit briefs addressing whether the en banc panel, group of judges, should have heard the case in the first place. In plain language, they're asking, did we mess up by getting involved, or is this the right path? Now that's a little bit like a football team calling a timeout during a game to ask the opposing team, do you think we should even be playing right now? It's unusual to say the least, and it has led to some head-scratching in the legal community. This move by the Ninth Circuit implies a level of confusion or uncertainty within the court about its own handling of the matter. It's like they're second-guessing their own decision.
You are issued weapons that allow for fully automatic and 3-round bursts. That is not available for purchase.
That men and women in this country have the right to defend their own lives.
In the world of law, where clarity and precedent are vital, this kind of self-doubt is a bit of a head-scratcher. So, what does this all mean? Well, it suggests that the Ninth Circuit may not be entirely sure of the path it's taken in this case. They've got some legal cold feet, if you will. And when it's a case that involves fundamental rights like those protected by the Second Amendment, those cold feet can send ripples of concern through the legal community. The big question here is whether this unusual request for briefs is just a hiccup in the legal process or a sign of deeper issues within the Ninth Circuit. It's a little like watching a plot twist in a courtroom drama, except this time it's happening in real life. Whatever the outcome, one thing's for sure: this case has turned into a legal roller coaster with more unexpected twists and turns than a summer blockbuster. And as for the Ninth Circuit's unusual move, it's opened up a whole new chapter in a debate that's already captured the attention of many, from legal scholars to everyday citizens. So, stay tuned, because this case is far from over, and the Ninth Circuit's decision to ask for briefs has left us all scratching our heads. Alleged delay tactics. Let's talk about what some folks are saying about the Ninth Circuit Court's actions in the case of California's high-capacity mag ban. It's a bit like unraveling a mystery, but some are suggesting that there might be some deliberate delay tactics at play. Now, to set the stage, here's what's happened so far. The case made its way to the Supreme Court, which sent it back down to the Ninth Circuit saying, "You need to take another look at this." Seems pretty straightforward, right? But that's not what happened. Instead of just reevaluating the case with a 3-judge panel, the Ninth Circuit decided to get the whole gang together in what's known as an en banc panel.
Here's a 12-round magazine. This magazine would be banned under this current bill. It doesn't fit.
How I am and my kids are going to be safer if I lock up my guns. I just feel, actually, as a female, I feel not as safe.
For God's sake, America already has more guns than people. How many guns do we need until everybody is safe?
Think of it as calling a team meeting when you could have just sent a quick email. This isn't entirely unheard of, but in this case, it led to some head-scratching. The real kicker came when the Ninth Circuit issued a request for briefs, asking the parties involved if they even did the right thing by getting involved in the first place. It's like the coach calling a timeout and asking, "Are we even supposed to be on this field?" Now here's where the alleged delay tactics come into play. Some observers are suggesting that the Ninth Circuit might be intentionally dragging its feet in the legal process. Instead of a straightforward reassessment, they've created more steps, more documents, and more opportunities for further debate to an already complex legal battle. And the debate over whether it's a legitimate legal maneuver or a questionable delay tactic will likely continue to swirl as the case unfolds. Implications for Second Amendment rights. Now let's get to the heart of the matter, the implications for our cherished Second Amendment rights. This legal dispute isn't just another courtroom drama. It's a battle with potentially far-reaching consequences for the fundamental rights of Americans. At the core of the Second Amendment is the right to bear arms. It's a cornerstone of our Constitution and a symbol of personal liberty.
The Second Amendment to the United States Constitution, Mr. President, as you well know,
fairly evident that the Ninth Circuit Court of Appeals has absolutely no respect for at least one of your rights.
Your right to own a gun can also be restricted.
The debate over gun control versus gun rights has been raging for years, and it's a hot topic for good reason. The ban on high-capacity mags, with a seemingly arbitrary limit of 10 rounds, raises some major concerns. You see, this isn't just about how many rounds a mag can hold. It's about whether the government can regulate an essential aspect of our self-defense and our ability to exercise our Second Amendment rights. Those who support the ban argue that it's a necessary step in addressing public safety concerns. They believe that by restricting the capacity of mags, it can potentially reduce the impact of mass shootings and make it more challenging for criminals to inflict harm. However, the other side of the argument, which is passionately defended by gun rights advocates, revolves around the principle that any infringement on Second Amendment rights should be thoroughly justified and proven to be necessary. They argue that the ban on high-capacity mags might not actually enhance public safety and instead could hinder law-abiding citizens' ability to protect themselves and their loved ones effectively. So what are the implications? Well, this legal dispute has the potential to set a precedent in terms of how far the government can go in regulating firearms and ammunition. If a seemingly arbitrary limit can be imposed on mag capacity without rigorous justification, it opens the door to further restrictions. The concern isn't just about the ban itself, it's about what it represents. It's about the potential erosion of our constitutional rights and the notion that the government can chip away at them under the guise of public safety. It's a delicate balance between individual freedoms and societal security, and finding that equilibrium isn't easy. This case isn't just a debate about numbers or technical details. It's a reflection of a broader struggle over the boundaries of our rights and the scope of government authority. The outcome will have a significant impact on the ongoing national conversation about gun control and the Second Amendment.
Gun violence does not discriminate. It happens everywhere and all the time.
An assault weapon's only purpose is to kill people efficiently.
It has been happening everywhere all the time because you, Congress, have done nothing to prevent it.
So when we talk about the implications for Second Amendment rights, we're not just talking about one case or one state's law. We're discussing a fundamental aspect of our democracy, the balance between personal freedom and public safety. It's a conversation that goes far beyond the courtroom, touching the very core of our nation's values and principles. And as the legal dispute unfolds, it will continue to be a matter of great importance and concern for many. Supreme Court's potential role. Now let's take a step up the legal ladder and talk about the big player in the room, the U.S. Supreme Court. This isn't just a local legal tussle. It's a case with the potential to shape the very fabric of our nation's laws, especially when it comes to the Second Amendment. The path from the Ninth Circuit to the Supreme Court isn't a straightforward one, but it's a very real possibility in this case. The Supreme Court has the authority to take up cases that have a significant impact on the interpretation and application of the Constitution, and the Second Amendment is one of those areas where it has historically played a vital role. So, what's at stake here? Well, if the Supreme Court decides to hear this case, it could potentially set a groundbreaking precedent regarding the Second Amendment. It's not just about California's high-capacity mag ban anymore. It's about the broader question of how far the government can go in regulating our right to bear arms.
They say that when we argue for removing weapons of war from the streets of America, we're actually telling them to repeal the Second Amendment.
To the newsroom, California cannot ban gun owners from having detachable magazines that hold more than 10 rounds.
They are obsessed with attacking law-abiding Americans' Second Amendment liberties.
The Supreme Court's role is not just to make a final decision on this specific law, but to provide guidance for the entire nation. Their ruling could establish a framework for how lower courts should approach similar cases, and it could clarify the scope and limits of the Second Amendment. And let's not forget that the composition of the Supreme Court can change over time. New justices are appointed, and they bring their own interpretations of the law and the Constitution. So depending on when this case reaches the Supreme Court, it might get a fresh set of eyes that could significantly affect the outcome. But here's the deal. No matter which way the Supreme Court leans, it's guaranteed to be a landmark decision. If they uphold the Ninth Circuit's decision and support California's high-capacity mag ban, it could set a precedent for stricter gun control measures in other states. On the flip side, if they overturn it, it would send a powerful message about the significance of Second Amendment rights.
Gives private citizens the right to possess a firearm, including a pistol.
Do you expect that this will go all the way to the Supreme Court?
Yeah. That's not a right of government. That's a right that each of us has as Americans.
In a way, this case is like the grand finale of a fireworks show, where you're expecting the most spectacular display. The Supreme Court's potential role could be the climax of a long-running debate over gun control and individual freedoms. So while this case may be tangled up in the courts and might seem like a never-ending legal saga, it has the potential to reach the highest echelon of our judicial system. And the decisions made at that level will reverberate far beyond California, affecting the interpretation and application of the Second Amendment for years to come. It's a waiting game, but it's one that could significantly redefine the boundaries of our constitutional rights. Controversial Ninth Circuit actions. Let's take a closer look at what's got people riled up in the legal world, the Ninth Circuit's actions and procedures in handling this case. It's not just the case itself that's controversial, it's also about how the Ninth Circuit has been managing it, or some would say, mishandling it. First off, it's important to understand that the Ninth Circuit Court of Appeals is the largest and one of the most influential federal appellate courts in the U.S. They handle a vast number of cases, and they play a significant role in shaping legal precedent. However, their handling of this particular case has raised more than a few eyebrows. The decision to ask for briefs from the parties involved about whether they should have even heard the case in the first place is highly unusual.
How far the Ninth Circuit will actually go to support California and its infringements on your Second Amendment rights.
We are paying for these weapons of war on our streets with the blood of our children.
But one of the questions that they asked to be submitted in their brief,
it's like a ship captain suddenly asking the crew, is this the right course? That kind of self-doubt and questioning of their own procedures is far from typical. And that's not all. The Ninth Circuit's decision to skip the three-judge panel and opt for an en banc hearing, which involves a larger group of judges, has also been met with criticism. It's not that using an en banc panel is inherently wrong, but it's a bit like calling an entire orchestra to play a single note. It's more cumbersome, time-consuming, and unusual.
whether or not that the en banc panel should even have heard this in the first place. Maybe it should have gone to the three-judge panel.
Mr. Chairman, we are not telling them to repeal the Second Amendment. We are telling them to read the Second Amendment.
What they did in determining that appeal for a stay was even the correct process.
The lack of clarity in the Ninth Circuit's actions is also an issue. When a court makes decisions that seem to depart from established legal procedures, it can create confusion and uncertainty. The legal process is supposed to be transparent and consistent, but this case has thrown a bit of a curveball. So why does all of this matter? Well, the controversy isn't just about the specific case. It's about the integrity and reliability of the legal system. Legal procedures exist for a reason, to ensure that cases are handled fairly, transparently, and consistently. When a court departs from these procedures or appears uncertain about its own actions, it can erode trust in the legal process. Concerns about infringement. Let's get down to what's really got people up in arms: concerns about potential infringements on our constitutional rights. It's the heart of the matter and the reason why this case is causing such a ruckus. The Constitution is the backbone of our democracy, and the Bill of Rights, including the Second Amendment, is a crucial part of it. It's what guarantees our individual freedoms and liberties. So when there are concerns that a law, like California's high-capacity mag ban, might infringe upon those rights, it's a big deal. For many gun owners and Second Amendment advocates, the right to bear arms isn't just a legal concept, it's a fundamental part of their identity and a critical aspect of their ability to protect themselves and their loved ones. So when any law is seen as infringing on that right, it's met with fierce resistance. The concerns here revolve around whether the Ninth Circuit's actions and the California law itself might overstep the boundaries of the Constitution. You see, the Second Amendment isn't an unlimited right. It can be regulated, but those regulations must be reasonable and justifiable. Many argue that the ban on high-capacity mags, with its arbitrary 10-round limit, might not meet that standard.
Placed an injunction against California's enforcement of what they consider to be so-called high-capacity magazines.
They are coming for your guns. They're listing them out in this extensive legislation.
But for some reason, that seems to be the number that everybody has settled on. Anything more than that is bad and is not good to go.
They see it as an infringement on their right to choose how to defend themselves, which they believe is a basic human right. The fact that the Ninth Circuit, in its unusual decision-making process, has opened up questions about whether they handled the case correctly only adds fuel to the fire. It suggests that even the court might have some doubts about the constitutionality of the law and their own role in it. This concern about the potential infringement on constitutional rights goes beyond just the Second Amendment. It's about the principle that the government should not infringe upon our rights without a compelling reason. It's about questioning the balance between individual liberties and public safety, which is a conversation that's been ongoing since the founding of our nation. So, when we talk about concerns regarding the potential infringement on constitutional rights, we're not just talking about this case in isolation. We're talking about the broader debate over the scope of government authority and the limits placed on it by the Constitution. It's a conversation that strikes at the heart of American values, and it's one that will continue to be fiercely debated as this case unfolds. It's about defending our liberties and ensuring that our constitutional rights are protected, no matter where the legal battles may lead.
Nothing's going to change for the foreseeable future. And when I say that, I mean for years.
The American people have considered the handgun to be the quintessential.
I think most of these laws with firearms in California, in this space, that's where they're going to be pushed.
That's all for this video, folks. See you next time.